Yeah, I'm Larry Tribe. I guess my official name is Laurence H. Tribe, and I'm the Carl M. Loeb University Professor at Harvard Law School and Professor of Constitutional Law. Well, the Obamacare case was an odd mix of a case that began with broccoli, when everybody was saying it was a wonderful image. Do you really want to have a government that can tell you you've got to eat your broccoli? Of course, Obamacare didn't make anybody eat his broccoli or buy her broccoli. It just said if you're going to use health care, and everybody does, you've got to pay for it with insurance. But there was a powerful sense in which forcing people to buy a product they didn't want to buy seemed un-American. It seemed an invasion of liberty. But the existing legal principles about invading liberty were not very sturdy. That is, the government can make you vaccinate yourself in order to avoid the spread of a disease. Government can make you wear seatbelts. The state of Massachusetts can force people to buy health care. So what was special about Obamacare that made it offensive? Well, it turned out that what was special in some ways was that it came from the national government rather than the states. And so there was this powerful developing argument that the federal government has to be cabined and limited in various ways. And I thought it pretty clear at the outset that the court's approach to this was going to distinguish between two fundamental uses of federal power: a coercive use that actually makes people do things like buy health insurance, and an incentive use that basically nudges people toward doing it by simply increasing their tax liability if they don't. And it turns out that that's the way Obamacare managed to survive. That is, I thought and said publicly, both before and after the oral argument, that it was likely that Chief Justice Roberts would cast the decisive vote to uphold Obamacare, not as an exercise of a rather frightening national coercive power, but as an exercise of a mild power, he thought of it as mild, to increase people's tax liability so that the burden they are putting on the system is covered by the taxes they pay if they are not going to buy insurance. That is, in the way the oral argument developed, it became a case of the federal government giving you a choice, either buy the insurance or pay more tax. And once it was put that way, I was predicting that Roberts would render the final decision based on the taxing power, and indeed he did. I don't think it was that much of a surprise if you think of the way he evolved as a student of the law. At the same time, there was this other half of the case in which 7 of the 9 justices, including 2 of the more liberal justices, Breyer and Kagan, held that the federal government does not have the power to force the states to accept its expanded Medicaid program, even though it's going to subsidize that program, almost to the tune of 95%. When the Obama administration lost that part of the case, that is, the federal government can't use its club of threatening to withdraw all of Medicaid as the penalty for a state that doesn't go along with expanded Medicaid, it sort of looked to a lot of observers as though Roberts was being a master politician. He was giving one to the Republicans, no Medicaid coerced on the states. He was giving one to the Democrats. Your purchase mandate will be upheld, whereas I saw the two pieces as entirely consistent, and we explain in this chapter why they are. They're both about an aversion to coercion. They're both about the idea that when the government can achieve its purposes by nudging people, by saying, if you don't do it, we'll increase your tax a bit, or we will deprive you of something, but not threaten you with imprisonment. Both parts of the case suggested that when the government stops short of coercion and uses inducement, financial inducement, it's more likely to succeed. Now, in the book, we explain what are the limits of that principle. But what was fascinating about Obamacare is that what would otherwise have been a dramatic defeat for the leading effort by this administration to achieve something that prior administrations had tried for 100 years to achieve, became instead a decision that put the ball back in the political court of implementation. Of course, the program was botched in its initial implementation, but now it seems to be on its way. And it was an example of the court acting not in what some people regard as a purely political way, but in a way that responds to principle.